Mexico is can be a very difficult country to do business in, but it presents a lot of opportunities, but also some very interesting challenges. But I think you'll find out that the challenges are far outweighed by the possibility of growth in business. Now, when we started our company, I had to face a lot of the same challenges that my clients face. So I kind of have experience from the very beginning to the end. I think we started out as a very small operation, but we now represent about 4% of all U.S. corporations in Mexico per year. Some of our clients include Qualcomm and Vizio. We have several projects that we do with Amazon in conjunction. So we try to make our clients' dreams come true, so to speak, in Mexico, besides some of the more challenging aspects. So we'll begin by reviewing some of the corporate forms in Mexico. So the SARSAV, this is going to be the equivalent of your corporation. Now, this is for primarily if you have a large number of shareholders, more complex operations, and people or participants in capital that are dealing with each other at arm's length. There's more corporate formalities. I think the biggest challenge here is sort of getting those corporate formalities completed on a monthly basis if you want to comply with the letter of the law. For example, there's a commissioner requirement, and the commissioner acts on behalf of the shareholders and has to receive reports from the board of directors on a monthly basis. So you can see how this can sort of get out of hand if you have just a subsidiary for administrative purposes. What you'll find more commonly is the Sociedad de Responsabilidad Limitada. I'll refer to most of the things in English, so don't get scared. So this is going to be the equivalent of the limited liability company, or the US LLC. And so, for example, if you go and buy something at Best Buy, right, in Mexico, you'll see that on the receipt it'll say Best Buy SRL de CV, limited liability company. Why? Because it's the most common form, especially for American investors, to enter the Mexican market. The IRS gives it favorable tax treatment. It's applied to what's called the hybrid entity rule, which means it's treated as a check-the-box pass-through entity. So, of course, if you're getting a lot of revenue from Mexico, that has tremendous number of benefits. Also, we have the SAPI. You won't see this too much. Most of the time, the SAPI is essentially just a variation of the standard corporation, and it's used for primarily for raising local capital. It has a series of minority shareholders' rights, a bunch of boring legal terms that I won't get into too much detail in right now, but you might see that in a few instances, but it won't be that common. The second part is we're going to look at the fundamental considerations for formations. There is the two-shareholder requirement, and that basically means that there's no such thing as a wholly owned company in Mexico. A lot of times clients will come and they'll say, well, I just want to own the whole thing. Well, we have to be creative about it, because it doesn't matter what the percentage is. If you have 1% for one shareholder and then 99.9% for another shareholder, you still have to comply with the two-shareholder requirement. And I guess for us in the United States, that is somewhat of the most bizarre aspect. Formalities, the notarization of the articles of incorporation. Really, it goes beyond the incorporation process. It goes right on into the actual ongoing business of the company. The notary plays a central role. Karen said that Mexico is not unique in that aspect. Most civil countries, the notary plays a huge role. Here you can go to whatever bank, your grocery store, get something notarized. No, notaries are a very huge implication for any type of corporate endeavors in Mexico. Now, the other aspect that Karen touched on was separate tax registrations. So the actual incorporation process is only the beginning. There are a whole series of subsequent registrations and subsequent bureaucracy that you have to deal with to get those registrations. So in Mexico, corporate law is inextricably linked to tax law. And that's something that's very, very, very different. Here in the United States, all we do is file for your company maybe once a year, an annual filing for your tax registration, or you file with the IRS whatever your earnings were, and that's it. In Mexico, that's done on a monthly basis. So also, Mexico has a pretty broad regime for foreign investment. So that means any companies that have foreign investment or foreign shareholders, they have to register with the National Registry of Foreign Investment, which isn't all that difficult. If you get into more sensitive industries, then that can be an issue. Okay. Now, we're going to talk about, basically, we're going to take you through a walk through a standard articles of incorporation. We decided that was a little bit too much. So these are the basic points that you should be able to find if you have clients from Mexico. I think the biggest thing to know is, of course, we talked about the notary. You want to make sure that you know where the document was notarized, because in most cases that will be the registry where the document or the company has all its corporate registrations. So in Mexico you have, for example, every notarized document has a public deed number. So don't be surprised that when you see at the very beginning there's going to be a number that says the notary name, the notary number, and then also document number 10,535. Because the entire course of a notary's career, for every single document they ever had, including corporate documents, they're going to have, starting from number 1 to number 100,032 after 40 years of the notary's practice, your document's going to have a unique number. So that's very, very different. Also, in the Articles of Incorporation, this is kind of a misnomer. We're used to saying maybe 2 or 3 different documents that are the formal documents in common law jurisdiction: your certificate of formation, your bylaws, and then your resolutions. Most of those, at least for the Articles of Incorporation and the bylaws, it's all the same document. So a lot of times companies ask me, well, what about my Articles of Incorporation and my bylaws? They're all there. They're all there. And so also in that you'll find the list of directors and the list of corporate powers, which we're going to go to now. This is going to be very divergent from what we find in common law countries. Why? Because corporate powers, for one, they're not called corporate powers, they're called powers of attorney. And that usually scares people whenever you hear that word, power of attorney. And in Mexico, like other civil law countries, it's all defined by statute. In fact, there's only about 6 or 7 types of corporate powers of attorney. And this is a place where I recommend everybody pay very close attention to, because when we have clients who come in and they're asking about what can their local signatory or the local representative do, you kind of have to just look at the local, what the local representative has, and then go from there. So the first corporate power that you're going to see is the power for lawsuits and collections. That just basically means that the local representative or the signatory can walk into court and sue on behalf of the corporation. The labor powers, which means they can represent labor disputes. And the most important 2 powers are up next. The first one being the general power for administrative acts. This means that the person who wields this power of attorney can exercise basically sufficient authority to operate the business as a going concern on a daily basis, sign contracts, immaterial things, represent the company before the tax authorities, licensings, and things like that. So we'll talk about this more, but that's something that to keep in mind. The General Administrative Acts is going to be very, very important. The Ownership Acts power, which is referred to in Spanish as actos de dominio. I'll switch to the English, don't worry again. And this is basically the full power of attorney that allows you to get rid of property, open up do any type of transaction that you need. In other words, you can significantly encumber the company with this type of power. So this is going to be reserved to people who are trusted local directors or local representatives with a history of working with the company, in my opinion. And then you obviously have later on the more minor powers, which are the obligations and debt securities power, the banking powers, and the customs powers. You want to pay close attention to these because a combination of one or the other may be required by your bank in order to have your local representative open up the bank account. So be aware, it's just a matter of checking with the bank and what their internal policies are. Okay. Now, restrictions on powers of attorney. A lot of times clients will want to say, well, I want this person to be able to do this and not that, only operate the bank account up to a certain amount, and they try to put all that information within the Articles of Incorporation. Restrictions are not a very good thing to put in the Articles of Incorporation. What you want to do is put that at the level of execution. So, for example, if you're executing a banking document, you want to put the restriction in the banking document, the banking contract, not the Articles of Incorporation. One time we were opening up a bank account for a client at Banorte, which is one of the major banks, and we put a restrictive covenant in the Articles of Incorporation in the person's corporate power. What happened was, it was throwing a curveball to the bank executives. It took them weeks, months, about 4 months to review the documentation, and because they just didn't know if the person had the sufficient authority to do what they were saying they were going to do, and it just ended up being a mess. So my point is, do not put restrictive covenants in the document itself, and at the point of execution, as I said before, is where you really want to make sure that you have any type of restrictions on the use. Okay. So we want to make sure that you need to think about the specific tasks that the person is going to have to undertake, and you'll have to match up those tasks to the specific powers of attorney and see, and basically that'll permit the person to act on behalf of the company in whatever way that they need to, with the sufficient authority that they need to. The most important thing is, I guess, a big difference compared to common law jurisdictions is the local agent requirement. So, as Karen said, the U.S. is really the only place in the world where you have the strict local agent requirement where they just receive service of process. In Mexico, for example, you are really on the hook with the corporation as the local representative, but it's a necessary evil. For example, if you want to get the company up and running as far as the tax registrations, you as a foreigner will have to rely on your local agent to get those tax registrations. You won't be able to sign all the documentation as a foreigner. It is possible for you to fly down, get Mexican residency, and handle everything yourself. That will add months to your process. It's just so impractical. So in most cases, for example, with customs broker documentation, we sign all our customs broker documentation for our clients. We get all their tax ID, registrations completed, and anything else that they need. The big difference between, let's say, a local agent versus a local director, this is a big question. And why? Because all companies are going to require a local agent in most cases, even for fairly immaterial things. But then they say, well, what about a local director? Okay. Well, the difference between a local agent and a local director is really a matter of degree. So a local agent would only need to have a power of attorney for administration, which we talked about a little bit earlier and what that implies. But a local director will have a whole series of powers. Of all the 7 or 8 powers that we had, they might have all of them. And so that also comes with some type of liability. The liability of the local agent and the local director is very high in Mexico. So that's why you'll see, in some cases, increase in cost in that area. So, for example, when it comes to liability for property liens or, let's say, personal liability for filling out documentation where you have to swear under oath that different facts about the company are correct, the local agent is going to have a lot of responsibility. I can think of one of the common areas is when all companies in Mexico have to make employment deductions and contributions by way of what's called the IMSS, the Mexican Social Security Institute. So if you do not, if you're not current on your employment deductions, that can cause tremendous problems. They will possibly knock on your door and say, here, you owe this amount of money, and you need to pay it in 2 business days, and if you don't, we will lien the property. And guess what? Even if you're only renting the property, your company doesn't own the office where you're in, they will still lien the property. Right? So limited liability and the idea of the corporate veil is something to take into consideration, and don't be surprised if there's some increased cost compared to your home jurisdiction. Local banking considerations, this is something that's very, very important. For example, signing authority is always difficult, right? Some banks will allow foreigners to sign. Some banks won't. Some banks will require that the client come and fly down to Mexico to sign the document in person. Some will allow the documents to be signed by FedEx. But the point is, you want to make sure that the person who is executing the banking documents does not have to be a Mexican national. And 2, you want to see if they're going to require the physical presence of the client for the signature of the corporate documents. Our company, we have a relationship with our bank where we allow the client, or the bank allows us to mail the client the corporate contracts so they don't have to ever come to Mexico. But most importantly, they don't have to get Mexican residency to have the document signed. And that's very good for civil liability, because if you have your local agent sign the corporate documentation for the bank account, then of course there's other issues of funny business going on. So, to say the least, so those are very important considerations, and they may change from bank region, bank branch, or even bank executive. So be prepared for that. Okay. So next we're going to move into the process for incorporation of legal entities, which I guess is the actual purpose of this part of the conversation. Okay. So all documents from the parent company and shareholders must be provided by apostille. Basically, I remember one client we were incorporating last week was in a really big rush to open up what's called a maquiladora manufacturing operation, and he sent copies of his documents in PDF to me, and he said, I get back to him with an instructional memorandum exactly what he needs to do with those documents, and I said, you need to get them from the Secretary of State, and get them a notarized, a certified copy, and have them apostilled. He said, well, I thought that the PDF would be sufficient, blah, blah, blah. I said, no, we were clear from that from the very beginning. So it would be nice if that were the case, but the point is, every time you have a document that's going to be a foreign document used in Mexico, it needs to be apostilled. They're very big on this requirement. So another thing is, point number 2 is the execution powers of attorney. This is only the case that you have incorporation from abroad. That is to say that the actual incorporators will not be traveling to Mexico. A lot of people try to say that you have to come and fly to Mexico to incorporate. It's not true. You can use a limited power of attorney and have somebody sign the documents on your behalf. It's so much easier. You don't have to pay for hotels or flights or anything like that. Legal translations. Another thing, any documents from abroad have to be translated by a translator in Mexico. So we have clients, one client from China came in and they had all their documents translated, and they said, oh, we did the favor of you getting the documents translated. I said, no, we have to actually have it translated within Mexico by somebody certified by the federal government. So that's something to keep in mind. Lots of little formalities that can sort of cause hiccups. Anyway, so the next point here is, of course, the execution of the RLC of incorporation. One way or another, someone has to be physically present, and that is by the POA or the client flying down. We talked about that a bit. But really, and Karen, when she warned you guys, we were going to talk about this in detail, about the massive number of registrations that have to take place post-incorporation. So once the documents are notarized, you have articles of incorporation in your hand, you say, congratulations. You can't do anything yet. So you have to all these subsequent documents, not the least of which is the RFC tax ID number. For example, if you're selling on Amazon in Mexico, you have to have the tax ID number. If you want to onboard with a new client or supplier, they're going to want you to have their tax ID number. The second part is what's called the FIEL, and that basically stands for the company's digital signature. And this is required not necessarily at the beginning, but towards the latter part of the incorporation when you're really going to start billing, okay? And I guess the problem with this is recently there have been delays. Legal speak, hold on for a second. Rule number 2.2.15. This has been the bane of my existence for the past year. Okay. First, in order to get the digital tax signature at random, and by at random we're talking maybe about 85% of the time, especially if the company has foreign capital, you sit down at the tax office, you go through the entire process of getting the digital signature, and at the very end, they tell you, nope, sorry, you have to go through revision and do the whole process over again. And by the way, we have to visit your office. So they come by. They're very nice people. We usually can sit down and have coffee with them and things like that. But they want to confirm that the company is actually legitimate. Big problem with money laundering and things like that. The problem is this process, if it happens to you, very sorry, it can increase the incorporation time by up to 15 business days. Yeah. So that's something definitely to keep in mind, because a lot of times people come in and they say, I have $1 million shipment that needs to get crossed through customs. Well, you can't do that if you don't have your electronic tax signature. So start early. That's all I say. And finally, we did talk about foreign investment registrations. You really don't have to look at this or think too much about it unless you're in a restricted industry, like oil or energy, or if you're owning property along the coast. But that's something to consider. You have to make sure your foreign investment registrations and foreign capital are registered, and before you can consider yourself completely incorporated and ready to do business.